Welcome to the Discourse KE. This is another episode, and today's discussion we're going to focus on the data protection and the data privacy law in Kenya. What do you know about the data privacy law? How often can someone take your data and use it for legal purposes? My guest today is Philip Kisaka, a lawyer and quite a young enthusiast about technology. Welcome, Philip.
Thank you very much for having me on the show today. My name is Philip Kisaka, as you said. I am a lawyer by profession with a bias for technology, media, and telecommunication.
You talk about bias for technology. That's the starting point.
Yeah.
Why bias for technology?
I mean, from a very young age, I've always had a passion for IT and computers and all that. But then later in life, I discovered that I also have a passion for the law and all that. So when you combine the law and technology, you become a technology lawyer, and I think that is what I'm trying to set myself out to be.
Yeah. Now, quite an impressive background there. Let's talk about the safety and privacy of data of Kenyans. How safe is Kenyans when it comes to data?
So I think we are not safe. We are very far from being safe. But again, in the context of your question, I'll answer it in two parts, and I'll answer it in terms of describing what data privacy is and what data security is.
Yes.
So these are really two different and distinct terms that are used interchangeably, wrongly so. Why do I say this? Because data security focuses on how to protect data from compromise against external attackers and internal malicious actors. While data privacy focuses on how the data is collected, it is stored, it is deleted, and what have you. To use an analogy is Google. If you have a Gmail account today, the password is how you protect the data within your account. But how Google uses your data to administer their account is what we call data privacy. To further analogize this is, let's say you built a building and you put an opening for a window. If you do not put the window panes in the glass, anybody can come up the wall and access the house. So data protection looks like this. You've put the window. But what you've not done is you've not now put in the privacy into the data, so that anyone can come up, can peep through the window, but they cannot access the house. So privacy looks like this. Now you put a curtain, and now someone can come up the wall, but they can try peep into the window, but they cannot see in. So what I'm trying to say is that data security and data protection and data privacy are two distinct terms. Privacy cannot exist independently without there being security. And data security is a construct of IT, while data privacy is a construct of the law, so to speak.
Yeah. Now, speaking of the law, let's talk about the Data Protection Act of 2019. Now, this Data Protection Act, what will it address? Because now, and does it have anything to do with what happened in the previous elections when it comes to the Cambridge Analytica, relating this to the Data Protection Act of 2019? What does it entail?
I mean, the Data Protection Act is a very wide document. Many people have said that it is similar to the GDPR, that is the General Data Protection Rights.
For Europe.
Yeah, from the UK and Europe and all that. But it has a bit of differences here and there, specifically in terms of the political rights and what have you, and the way to administer political data and how to push campaigns through already collected data by the government. But the Data Protection Act has just come in to help Kenyans maintain and regain control of their personal data. And in terms of regaining control, there's the principles of data protection that are in the Data Protection Act. So we have lawful purposes for processing data. We have things like consent, we have accountability, transparency, and all those things. So these things are trying to return the power back to the data subject, because for a very long time there's been an imbalance of power in terms of data, because you find people like employers. So you want a job and the employer asks you for the most intimate details of your life. They ask you your marital status, they ask you your date of birth, your ID number. So there's always been an imbalance of power. So what the Data Protection Act is trying to do through the Act itself and the draft regulations that have been drafted is that it is trying to return back the power to the data subject.
So does that mean that if someone asks you, especially an employer, when it comes to your data, you have right to deny keeping the data?
I mean, Logically speaking and legally, not legally speaking, you have the right to deny. But again, it is an imbalance of power because if this is your employer or potential employer and they're asking for details 1, 2, 3 before they actually call you in for an interview, you sort of have no alternative or you have no option to refuse and say, I will not give this data, but I still want this job. So there's an imbalance of power in terms of employers, and secondly, in terms of the government. Because the government, in terms of, let us talk about things like you want to get a passport today. The government will require you to give the most intimate details of your personal life. I mean, if you're a minor, your parents' details and all that, if they're deceased and what have you. So in terms of employers and government, there's always that imbalance of power.
Okay, and about power now, let's boil it down to the elections. Because the Data Protection Act, I believe, is also to protect people when it comes to elections. Taking it back in 2013 and 2017, there were allegations, and also we saw an expose by Vice News, which was saying talked about the Cambridge Analytica. And actually, they were caught on camera. They were saying that we had rebranded the entire party twice, written their manifesto, done rounds of 50,000 surveys. Now, this is Cambridge Analytica, and most countries actually have accused Cambridge Analytica of being involved. US inclusive, the UK inclusive when it comes to the Brexit, and also the US in the 2017 election, and many other countries, almost 32 countries. Now, how best can this be tamed when it comes to data protection in the international companies?
Yeah. So you look at Cambridge Analytica and you realize one thing, that the countries that were most affected were either the countries in the Caribbean or African countries. And these are countries that normally or would ordinarily not have very stringent data privacy laws, or the data privacy laws, even if are in place, they would be very lax. So Cambridge Analytica really exploited this desire for power by the African leaders. And I mean, as Africans, we are our own enemies. So you find this is a politician, they have access to crucial data of the whole country. Case in point, I mean, you've seen the Huduma number. So they have data of the whole country, and they're able to now hand over this data to the guys at Cambridge Analytica, and these guys are able to compartmentalize the data and say, okay, for this segment of the country, we're going to use this kind of smear campaign against this politician. For this segment of the country, you're going to paint this politician as the best option and all that. And I feel the best way to handle this is to come up with a framework as Africa that is going to inform how data is supposed to be exploited in terms of Africans. And it is also going to sort of act as a GDPR for the African continent. Because right now, countries have different laws and they're not harmonized. This ones give these rights, this ones give these rights. But if we have one harmonized document, and it's a document that has been ratified by the AU, I'm trying to remember the name. I cannot remember the name right now. But only 15 countries have ratified that document out of 55 African countries. This just shows you a disinterest in the African continent in terms of complying with data privacy laws. So I think moving forward, we need to have that harmonization of the law to just say that as Africa, this is how we protect our data, this is how it is supposed to be exploited, and what have you.
It talks about AU being ratified, 15 countries ratifying a resolution to the AU. Now, talking of the AU, some years back, we had China been accused of bugging the AU headquarters in Addis Ababa. Now, how practical will it be when it comes to implementation of this document?
I mean, again, as I've said, as Africans, we are our biggest enemies. For a fact, I'd tell you that that allegation of China bugging the AU came 1 year later after they had discovered that there was suspected bugging of the AU, which just tells you that the African leaders are more focused on their relationship with China in terms of investment, rather than the protection of the privacy of the citizens of the African continent. So which just tells you that it really goes down to who are the people at the top. Because the people at the top really would not care much about surveillance and all that. And even you've seen it with the recent spyware, Pegasus.
Pegasus,
Yeah, where Rwanda is trying to spy on South Africa through Israel. I mean, it's a very complex web and all that. And the relationship between Rwanda and then South Africa has always been very, very shaky and all that. So it just tells that the surveillance has not only been one-sided, where a country in the west or in the east is trying to surveil on a country in Africa, but it has always been about how do I get a competitive advantage over this country and over this other country.
Okay, now bring it back to Kenya, the Data Protection Act of 2019. What are some of the loopholes in this Data Protection Act?
The biggest loophole I'd think of, or I'd like to point out, is in terms of the ODPC, the Office of the Data Protection Commissioner, being under the Ministry of Information Communication and Technology. It does not give that office the necessary independence it needs. Secondly, you look at the budget that was just read out. The budget that was set out for the ODPC is 50 million. And you look at something like the Cambridge Analytica, the investigation that went into it and all that, and the budget that was set out to actually just do the investigation, it was running in the millions of, if I was to convert it to Kenya shillings, millions of Kenya shillings. So you look at the law is in place, but the empowerment of the office is not there. It has been put under a ministry which does not give it the necessary independence. And I think that is the biggest gap we are experiencing in the
So you think it will stand on its own without being under the Ministry of Information and Communication Technology?
Yeah, I mean, it ought to be a state corporation on its own, so that it just stands on its own with a huge budget, because, I mean, investigations take money. For you to administer the office, you need experts, you need guys who are able to effectively carry out audits. But you see now, it being under the Ministry of ICT, and right now the staff are only they have been seconded from the Ministry of ICT and other ministries to just support the office. So without necessary manpower and necessary financial power, then the office becomes a ceremonial office.
Okay, now talking of the unlawful companies that have tried harvesting data and use it unlawfully. Recently we had the Office of the Registrar of Political Parties, and people are complaining, especially the netizens on Twitter. And people see, and even Raila Jr., I think he wrote something in regards to that. Now, how lawful or unlawful was it? Because they actually denied, they actually say that they were doing a trial basis when it comes to the portal. So how unlawful is it, and what are the steps one can take?
Yeah, so the first thing to answer your question is that data is always collected either in a primary form, which is you can come in, like if you're accessing this building today, you write your name, your ID number, your phone number, and then you leave it there. That is in the hard paper format, or it can be digital. Now, for the longest time, registration of political parties, registration of members into political parties was through a manual system.
Yes.
So you access the offices and then you write your name and all that. Then remember, the people inputting this data in the systems are also human beings. I mean, they are prone to error. And I'm not saying, and I'm not defending the office of the registrar of political parties, but you would find that in as much as you'd input your ID number, either the name appearing from the site would be different, and it will also give you a political party that you've not heard of.
Because if it's an error, that would be a very huge margin error. Because we saw many people actually. So John Alanam, who said actually he warned and said, if you are already checked in your but political registration status via e-citizen, consider changing your password. So it's like each and every person, it was all scrambled up.
Yeah, I mean, and it was very wrong for the ORPP to do that, and which goes and just boils down to if the data, or the Office of the Data Protection Commissioner was effective in terms of administering and doing audits and just policing this whole data thing, then we will not have this situation. And so moving forward, I think that the ODPC should really move into trying to identify how did, first of all, the registered political parties access this data, and secondly, how did he now upload it into the digital system, because I think that is where there's the disparity. Because in as much as people are complaining that their data has been taken and they've been registered for what have you political parties, there are people who are complaining that in fact the name and the ID number input were different. It just tells you that the people also inputting the data were not very accurate. But also it also boils down to people who've never registered for any political party and also found themselves as members of, I mean, yeah, whatever political parties.
Which question the which questions the credibility of the forthcoming election of 2022. And an article by Crispin Bosire, who on ensuring integrity of personal data ahead of 2022 election, and he wrote, I quote, "The political parties are ahead of the game than the Commissioner for data protection." And also, he said that it is now time to breathe life into the DPA, Data Protection Act of 2090, to enforce rights to privacy in Kenya. So how safe are Kenyans when it comes to the 2022 election, especially when it comes to harvesting of data?
Yeah, I mean, Crispin Bossi is my very good friend, and I know he'll be watching, so hi, Crispin. The Data Protection Act and giving life into it in terms of the political scene in 2022. There's a lot. I mean, there's a lot to be covered in terms of the data of Kenyans, and specifically, again, in relation to what we just talked about with Cambridge Analytica and arresting Kenyans' democracy by targeting specific groups with specific messages, either for smear campaigns or for painting someone as a saint in terms of their track record and who they are as a person. Yeah. So I wouldn't want to comment much on the 2022 elections because there are still very many moving parts. The Office of the Data Protection, the Office of the Data Protection, the ODPC has just been set up. There's the draft regulations that have just been put in place. They are not yet put into law. There's still public participation into that. So it's going to be very interesting to just see how, moving forward, the ODPC is going to administer, quote unquote, the 2022 elections in terms of data and data privacy and protection.
But can we say we are safe from data being harvested?
I mean, we're not safe. We're far from it. Very far from it. Very far from being safe. Because, and why I say this is that one of the elements or one of the principles of data privacy is consent. And consent has a number of parts to it. Consent needs to be freely given. And just to mention the second one is that consent does not have to have detriment when you do not consent to your data being processed. So let us say you're downloading an app and the app tells you allow access to contacts and whatever. We've seen this with Tala and these mobile loaning apps. Yes. If you do not allow consent to access all that, you should not be precluded from accessing the app. But how are things happening right now? Because the ODPC has just come in and the data protection has just come in, people are all over the place. So compliance is, if I may put it, is optional for many people right now. So you want to see the ODPC putting in the teeth into the game and just saying, okay, you're exploiting people on this front, this is a fine we've given you. And I also think it's a very good way for them to raise the money. As I just told you, the budget has allocated them 50 million. I mean, slap a fine here and there. At the end of the day, you find that you also increase the budget of the office.
So talking of consent, how often do people read that agreement and consent letter or something? Because we find that many people just consent to anything when it comes to, especially the apps. Downloading the apps, can we have access to your numbers? Someone just says yes. So now this brings me to an imbalance and a question of, are the people to blame or are the companies to blame?
I mean, again, I go back to the point I was talking about, imbalance of power. I really need this. Let me go back to the fintechs and the loan apps. Financial inclusion is a very key part of the economy. I mean, access to credit and all that should not be a reserve for the rich or for the middle class or whatever. It should be a reserve for everyone. So here you have an app, you have an issue you want to download. You want to get or you want to access some amount of money, and this app is gonna give you that amount of money. The problem is that before it gives you this amount of money, you need to consent to 1, 2, 3, 4. So already there's an imbalance of power because really need this money. I mean, for hospital, for school fees and all that. And the biggest thing is that it's not that people are giving so much data, it is that the imbalance of power has made people almost helpless. So, I mean, you want to access this, you have to consent to this.
You've talked about imbalance of power. Now, looking at the policies, especially that are being rolled out by most of these apps, to say someone actually mentioned on Twitter, that is Winston Wino, say that most of these policies are lengthy. Why is this the case?
So, in lengthy policies, basically why companies do that, or why I think companies do that, is to basically just protect themselves. So that in future, if someone is bringing an action, they're able to say, I mean, article this or clause this or paragraph this clearly states that we will use your data for this and what have you. So it is just companies trying to find a loophole because as a person trying to access an app or whatever, I want the shortest consumer journey possible. So reading through a 15-page, 20-page policy will not be in my interest.
Does that mean that's more of exploitation? Because I'm sure most of the people who even download these apps, they might know how to read, but they hardly read these policies.
Yeah. So the problem is that there needs to be a balance between the way the company is trying to protect itself as a company and in terms of exploitation of your data, and also the way you as a data subject are protecting yourself. So the company cannot be lax and say, I will give a 5 clause or our one pager policy, while in fact that one pager policy does not protect the company. So it just is, there's a balance. So the onus is also on us as data subjects to say that okay, I'm signing up for this. It's an account, it's an app and whatever, and I need to read through it and just understand what all this is. I also blame it on we consumers as being a bit lazy and now not really trying to actively participate in this whole data ecosystem.
Okay, now you answer the question of who to blame, especially now the people or the company, because I think it's a mutual correlation. Now about the data, it seems to be one oil or gold of the 21st century. Why is that?
So there's is it a scholar, a mathematician who say that data is the new oil, and just like oil, data in its raw format is not valuable. I mean, like crude oil, you need to refine it, then you convert it either to diesel or to petrol or to jet fuel and all that. So data in its rawest form is not valuable. But then when you now combine data sets and you say that I know Mamadi stays here, I know this is the kind of gadget he uses, I know this is the account he holds in this and this bank and all that, then you combine all those data sets, then you come up with a whole now new persona, and you're able to now target you and market to you specific products and all that. So data being the new oil is just in terms of you need to convert data from its rawest format into a format that can be exploited and used. Yeah.
Okay, and now going back to the Act, 2019 Act, and we mentioned about, you talk much about the privacy and harmonized way of doing of coming together, and also in all this. Now, how best can the two, especially the people and also the country, when it comes to harmonization, how best can it be way forward, chart a way forward?
Yes, I mean the best thing is that the data processors and data controllers need to also acknowledge that the people also need to have the power, so much so that it is not going to be an imbalance where we are here, we are controllers or processors, and your data subjects down here. It needs to be something where there's an equal playing field, where everyone is coming in, every player is coming in, they're saying, okay, I will consent to using my data to this extent. You can use it for marketing, you can develop a persona from this, and the controller is, or the processor is honest in what they're going to use the data for, so that it is not a situation where they're saying we'll use it for 1, 2, 3, then they end up selling it to a third party, or they end up using it for 4, 5, 6, 7, 8, and 9. So I think all players just need to sit together and understand that it is not a fight between controllers, processors, and subjects. On the other hand, it needs to be a synergy between. There needs to be a synergy between them, to just collaborate and work together moving forward.
All right. Perhaps the final statement comes to the privacy and what else do we need to know? Because we saw people complaining that some are receiving text actually from unknown numbers, and they were now questioning where are these people getting their number. People receive text maybe from a bed company. Now, this sounds like exploitation of these people. Now, what's the way forward to this, and how can someone what's the way forward to approaching this when it comes to the legal matter? You are in the legal profession. How best can someone approach this?
So yeah, I think this is my camera. So what I'd just like to say is that the Data Protection Act is a very baby act that has just been put into place, and we need to sort of give it time to metamorphosize into becoming a strong and actually becoming one of the pillars of the economy in terms of how to process our data, because I mean, as we just said, data is a new gold. There are also draft regulations that have gone out for public participation, and it will be very interesting to see how these regulations actually move in and just sort out this whole data confusion, because as it is right now, as I've just been saying, is that the problem with Kenyans is that compliance has been made sort of optional. So moving forward, I think that let us give it time. But as much as we're giving it time, the Office of the Data Protection Commissioner needs to be empowered, and we also need to find a way to remove the Office of the Data Protection Commissioner from being a department within the Ministry of Information, Communication and Technology. Thank you.
Philip Kisaka, thank you so much for coming to the Discourse KE. Thank you so much for joining us for the discussion, and I've been your host, Emmanuel Mamadi, and in collaboration with the Ukombozi Library and Prism, we've been delighted to bring to you this show. Till next time, God bless.